Hi, I'm Jared Haddock, and I'd like to discuss with you today the process for Chapter 7 bankruptcy. Chapter 7 involves quite a lot of paperwork. I have a required documents list on my website, although the documents that are required will vary from one case to the next depending on what's happening in that case. But generally speaking, there are quite a few documents that you'll have to submit to your attorney in order for them to build your bankruptcy petition. Once you've collected those documents together and submitted them to your attorney in a timely manner, there's a credit counseling session that you are required by law to complete before your case can be filed with the court. This credit counseling session can usually be completed online in the privacy of your own home if you have internet access, and will involve about a 5 or 10 minute phone call with a qualified credit counselor. Once you've completed that session, the credit counselor will provide a certificate of completion for your attorney to file along with your petition with the court. However, before your case can be filed, you have to review your petition. The petition usually ends up being about 50 to 60 pages long, and you should go through it in its entirety looking for any inaccuracies or changes that you should bring to your attorney's attention immediately. Once you sign that document, you do so under the penalty of perjury, that all the information contained within it is entirely truthful and accurate to the best of your knowledge, information, and belief. Your attorney will electronically file your petition with the bankruptcy court, and at that moment a couple of things happen. One, you're assigned a trustee and a hearing date and time, but secondly, a federal law will go into effect called the automatic stay, and that's what prohibits any creditor from making any further attempt to collect from you during the pendency of your bankruptcy. That automatic stay exists both for the creditor's benefit and for your benefit, but it's kind of one way to think of it as like a giant timeout that's issued by the court. What that means to you, of course, is that there will be no more phone calls or statements sent. About a week after filing, you'll get a letter from the court telling you who your trustee is and when and where your hearing will be held. That hearing, referred to as a Section 341 hearing, also called a meeting of creditors, should occur about 3 to 6 weeks after filing. That should give you ample time to arrange the day with your employer if you need time off, for instance, to attend that hearing. Your attorney will accompany you to that hearing or meet you at that hearing. The hearing itself is usually conducted by your trustee, and there is no judge present. The trustee will swear you in under oath and proceed to ask you a series of questions about your finances, assets, and obligations, any assets that you may have sold or transferred. You should answer them completely honestly. If you do not know the answer to a question, you should not guess. This is not the time to guess. This is, after all, a federal case, and so you want to be completely sure that you understand each question before you answer it. Your attorney should be there to interject if needed in order to clarify any information that the trustee is looking for. No decisions are made final at that hearing, and usually creditors are invited to attend, but rarely ever do. There are a few exceptions, however. Credit unions will always send an attorney, and some secured creditors may show up looking for reaffirmations, which I'll cover in another video on my website here. Creditors are given 60 days from that hearing date afterward to object to anything if they're going to. It's unusual to get creditor objections, but occasionally they may arise. After that 60 days has passed, the court will issue its ruling, but before they can do so, there is a second credit counseling session that must be completed. And that is a financial management course. It involves a 2-hour video that every debtor in bankruptcy must watch and certify their completion of to the court. After that's been done and 60 days have passed from the hearing, assuming that there have been no objections, that any objections have been resolved, the court will issue its ruling, usually in the form of a discharge notice, which means at that point that you no longer legally owe back any of the debts that were included in the petition that were dischargeable from bankruptcy. I say that because some debts are non-dischargeable in bankruptcy. As far as the long-term effects of bankruptcy go, it'll be on your credit report that you filed for Chapter 7 and discharged these debts for 10 years. How bad is that? It depends on what you're looking to do. Most mortgage companies would say wait at least 5 years after a discharge in bankruptcy in order to obtain a traditional mortgage again. Vehicles you can finance even while you're in a bankruptcy, but beware of the interest rates for the first 1.5 to 2 years. They're going to be higher than the average. Credit cards. It's not unusual for creditors to flood your mailbox with credit card offers after a bankruptcy. You should shred these as they come in. You want nothing at all to do with them. Credit card companies do this because they are trying to make up for their losses. They know that you cannot file bankruptcy again under Chapter 7 for 8 years. And so the more money they can recoup from that loss over that 8-year period, the less their bankruptcy will impact them. The sooner they get started with you back in debt, the better off they'll be. Don't fall for their tricks. Shred those offers as they come in. That basically sums up the process for Chapter 7 bankruptcy. I hope you enjoyed it, and thank you for watching.